Returning to my Coin Lady channel, I want to say hello to all of you. All XRP holders can take heart from this, my friends. We were correct in our opposition to the SEC and their baseless assertions regarding XRP's status as a security. Judge Torres found in our favor, while the SEC was found to be incorrect. Then it is what it is, the matter is resolved. An interesting thing happened, though. In a completely separate matter, a judge from a different judicial district upheld Judge Torres's ruling, citing Judge Torres's decision in the SEC v. Ripple case. The whole cryptocurrency market is currently and will be forever changed by the extent to which that verdict is influential. How significant that was is difficult to put into words. Through it all, we were all interdependent. Oh, and trust me, that was the worst. Even while the Ripple scenario is far from resolved during the remedies phase, at least we're no longer on the receiving end of it as XRP holders. We are, however, in a bull market and everything is okay. Therefore, I think we will enjoy ourselves. Still, I'd want to give you my 2 cents on the matter. I've heard the opinions of multiple lawyers, including Stewart, the chief legal officer of Ripple's, James Murphy, also known as Metal Lawman on AIX, and Bill Morgan, and I must say, this is an astonishing criticism. After listening to the SEC spew their usual load of bullshit, you're sure to enjoy this one. On the question of whether an asset constitutes a security, this court is systematically dismantling the SEC's baseless arguments. Furthermore, this is exactly what members of the community have been stating for years. That's why I mentioned before that it's a huge victory for us. This time, a judge from a different district stepped in to tell us we were wrong. Yep, you're totally right. I am not providing financial advice and have no prior experience in the field. Please understand this before we continue. Furthermore, you should know. Circumstances use anything I write or say to make a purchase or sale. I'm simply a casual YouTuber that enjoys dabbling in cryptocurrency as a pastime. Then there's the matter of fun. Proceeding with the purchase of that litigation, the court has allowed the majority of SEC allegations, according to this headline from Cointelegraph. That, at least at first glance, doesn't sound that thrilling. Even though the headline isn't XRP related, you should read the story because it is. First, I'll just give you the rundown of where everything is. The remainder of the film is devoted solely to discussing its meaning after we finish this brief introduction. Taken together, the events surrounding XRP and the SEC versus Ripple lawsuit have important implications for the future of cryptocurrency. The cryptocurrency exchange Binance was unable to persuade a U.S. judge to reject the majority of the securities regulator's charges against it. BNB's sale following its initial coin offering, claims pertaining to the financing staking program, and anti-fraud violations will be addressed. In a court filing dated June 28, Judge Amy Berman Jackson acknowledged that the security regulator's assertion that former Binance CEO CZ served as a control person will also be pursued. According to the plaintiffs, Nance had a duty to register with the Exchange Act. Nevertheless, the SEC could not achieve a clean sweep. In the end, Jackson decided to reject allegations pertaining to BNB secondary market sales and all sales pertaining to Nance USD stablecoin. It becomes intriguing after that, alright. I thought it would be helpful to provide you with some background information so you can understand the case in detail. It's definitely pertinent. Everything else, however, is relevant to the events surrounding the will to XRP holders and the SEC v. Ripple litigation. Reporter Eleanor Turat of Fox Business. This post was shared by her. And because I'll be presenting the views of several lawyers, there will be some repetition. However, I will do my best to avoid it, and the way I've planned the movie shouldn't make it too tedious. You've merely been listening to the same voices, repeating what isn't happening. Irrelevant anyhow. When asked about the newfound clarity around the sale of digital assets on the secondary market, Eleanor Turat replied the following. Justice Amy Berman of the district. According to Jackson's recent dismissal of the SEC's claims, BNB token secondary sales do in fact constitute securities under the Howey test. In her ruling on Howey, Elisa Torres used ripples as evidence that the practicality of the token transfers was relevant. The government's reliance on the statement that crypto assets are the embodiment of the investment contract is stated directly from a judge in a separate case, according to her ruling. Regarding the platform's interdependence and the technology's nature, there was an argument at the hearing. Furthermore, individual token performance is insufficient to classify BNB secondary sales as investment contracts. So, to take a step back, we're discussing transactions taking place on anonymous exchanges where the identity of the seller is completely concealed. She also referenced the embodiment idea, a theory I've been debunking here on the channel. I know I'm not alone, but I've spent years tearing this thing to bits, even before we got to the conclusion, at least from the perspective of XRP's legal clarity, even before that. Therefore, XRP is merely a symbol for the investment contract. Asking him, "Are you claiming XRP itself as a security?" reveals that the SEC is, as I've indicated before, trying to cover their tracks. It is not a security, I repeat. Well, then, what the fuck is happening here? As far as I'm concerned, all he can do is embody it. Well, it's the same thing when you prick your ass. Your freaking fool stick is causing you to speak with two different perspectives. Your tiny one has hatched a demon-possessed monster. The court went on to say that the deal doesn't quite line up with the government's one argument that they've been pushing ever since the lawsuit was launched. Contrary to popular belief, we are not claiming that the coins in question are securities, but rather investment contracts. Additionally, Ellen's return was marked by a brief message. As an aside, this is a quotation from the finance judge. She stated categorically that the agents. Once again, I am Judge Jackson, and I can say with confidence that the agency's stance on the industry in Cook has changed, and that they have not implemented a thorough regulatory strategy. Thank goodness. The SEC has been gaslighting us for years, you know. Yeah, I see exactly what you're saying. North Korean leader, Kim Jong-un. This is terrible. Well, I'd have to say it's decent. Quite evident. It is crystal clear. Both the rules and the guidelines are quite clear. The courts, however, hold a different opinion. Gensler, Kim Jong. Nothing pertaining to cryptocurrency has a complete regulatory standing. You can see it clearly. In this case, she said it. Therefore, you aren't paying attention. The medicines you've been taking have not been insane. This whole time, the SEC has been using gaslighting tactics on you. Following the initial post by Eleanor Turret, attorney John Deaton penned the following. The fact that my 75,000 XRP holders and I were instrumental in convincing Judge Tor to rule in the way she did is something I am very proud of, he added. With her ruling that XRP exchange sales did not breach securities laws, Judge Torres highlighted not just my amicus brief, but also other papers and the thousands of affidavits submitted by XRP holders. We asked her to determine that XRP is not a security, and she did so. I will pause the state at that point. Sure thing. We are all listening, everyone out there. Every one of us did our part. A large number of you, perhaps in the thousands, submitted affidavits. After hearing arguments from 75,000 clients, Judge Torres sided with attorney John Dean. Even if you didn't, chances are good that you're still involved with social media and reposting content all the time. When we joined forces, our voices could be heard far and wide. That was certainly known to Judge Torres. Things weren't going as well for Ripple generally, so even if they had gone well without it, I still think it made a major impact. She obviously understood the need to prove that XRP was not a security because we were all here. As an aside, it was not necessary for her to do that. Aside from the XRP community's constant yelling and cries, I still don't think she would have. Of course we did, and she took note and acted appropriately. That was done by our community. And now everyone else gets to reap the benefits, which is just fine with me, because I own a variety of cryptocurrencies. Thank you for watching my channel and for subscribing. I'll see you later.